All right, the next case on the court's calendar is Pinellas County versus the state of Florida. Are there 4 speakers on behalf of the appellants?
Actually, I'll just be myself.
Okay, thank you.
My name's Grace Dunlap. I'm here with the law firm of Bryant, Miller, and Olive. Also at the table with me this morning are 2 members of my firm, Ken Guckenberger and Randy Hanna. And at the end of the table is Assistant County Attorney Joe Morrissey. We're here this morning representing Pinellas County. I'll have 5 minutes for my rebuttal. This is a case of great concern to many local governments, and of course in particular to Pinellas County, because it's a challenge to the county commission of that county, a home rule charter county, to its efforts to provide water to its citizens. I think it's important to start with a few facts and have a little understanding of this particular utility system, of this particular charge, and of this particular project. This county has been charged with providing water to certain small municipalities along the Gulf of Mexico in Pinellas County. It has been charged as early as 1935 pursuant to a special act of the legislature, which is still in full force and effect. They've been mandated to provide water to these cities because they've been unable to provide water for themselves. And they have done so for over 60 years. So the most recent effort they've made in providing water, as they've been mandated to do, is to put in place a reclaimed water system. The county has 2 types of customers. They have wholesale water customers and they have retail water customers. The appellees in this case are retail water customers. There are actually 13 municipalities that are retail water customers. Their citizens are customers of the county's water system. And in this case, the water rates and the fees and the capital components thereof are adopted pursuant to a resolution of the county. And it's been done that way again since 1935. There's also a 1939 Special Act and a 1953 Special Act, which govern the way that rates are set and capital components are determined. And it's done in a reasonable manner, again, by the County Commission.
Your opposition seems to try to categorize the reclaimed water system as something different than a water system, and that seems to take the position that it must come under 153, and that's the only source of power that you would have to deal with it. How have other states addressed reclaimed water type of projects?
Well, Justice Lewis, I don't really even think you have to look to the other states. I think you can look to the Florida statutes and see that reclaimed water is mandated by the Florida legislature to be considered part of water. In Chapter 373 and in Chapter 403, the legislature has spoken and said water management districts in these areas such as Pinellas County, where potable water is at a premium and where you have what the statutory term is a water caution area, a water resource caution area, you have to look to reclaim water in order to use your local sources before you go outside and use other people's sources. And they specifically stated in both of those chapters that reclaimed water is water. That rose by any other name smells as sweet. So we would maintain that, in going to the Chapter 153 issue first, basically there are 2 issues. In the Chapter 153 issue, we think the trial court clearly erred in finding that 153 was in any way applicable to this case.
You do look out of state, though. What do the out-of-state cases or other states in their legislation or case decisions tell us about how they've treated the use of reclaimed water?
I think the other states tell us that reclaimed water is a source of water that you look to. Reclaimed water, let's talk a little bit about what reclaimed water is. I think the states have, in water shortage areas, we've stated that we can highly treat water, wastewater effluent, and then have that for a variety of uses. It's the type of water that we do have a different line that runs to the house, and the county is proposing to finance just the smaller distribution lines that go into these properties and the small hose bib or service box appurtenance at the property. And I think that is the way it has been done in other states, Your Honor.
Are you aware of any other case decisions from other states that have said no in terms of financing?
I have not, no. In our research, we haven't found it.
Differently.
No, we have not found that. Most of our research in other states has been focusing on the issue, quite frankly, about the way the fee has been imposed. But under 153, because I don't want to leave that argument, we feel very strongly that the trial court erred in making this determination, and we have several cases directly on point by this court which hold that very similar language in statutes does not apply when you're dealing with a home rule charter county. We would ask the court look to the Boca Raton case in particular, look at the second DCA Mountain case, and find that the language of 153 that talks about having a consent is not a general bar to a home rule county that's not availing itself of that particular chapter in adopting a utility fee. So if there aren't any questions on the 153, I'd like to go right into the issue, which is the second issue really that's involved in the case, which is this capital component utility charge, what's called an availability charge by the county and the ordinances, has it somehow become an invalid tax? And just because the county has stated that there's a certain class of users which are required to pay this fee, does it fall within the Port Orange case? The county maintains that we are very different than the Port Orange case. In this case, we are exercising a proprietary interest that the government has. We are acting, yes, under our home rule powers, but we also have a lot of statutes that are directly on point. In particular, Chapter 403 states that local governments can charge on a reasonable basis the cost for a reclaimed water system. We don't believe that there's any argument really that can overcome the fact that there is a general law directly on point which says that local governments can have these charges. We also have the special acts on point. The special acts go so far as to say the county could have had a mandatory connection charge for the reclaimed water. The county didn't go that far. The county, in fact, put in place a $7 charge and exempted out from the users that have non-potable water well on their property from the payment of the $7 fee. The $7 fee is a very small component. It's a 30-year fee, and it's recovering, again, the capital cost of putting in place the distribution lines in the neighborhood and the actual improvements there on the property for these property owners. It's not a usage fee. In other words, it's not a charge for the actual reclaimed water. If they hook up and choose to avail themselves of the service, it's an additional $2 fee. For that $2, they have the ability to water with this non-potable water, to pressure wash their boats, to have a decorative fountain, whatever they might want to do with this water, 7 days a week, 24 hours a day.
Did I understand you correctly? The $7 fee is paid whether you want to use reclaimed water or not. But if you do use reclaimed water, you pay an additional fee.
You pay an additional $2 unmetered rate for the use of the water.
So everyone in this area pays the $7 is the...
That's correct, unless they had a well on their property. It's not mandatory with respect to people who chose to opt out because. And to be candid with you, the county studied this whole process. They have a feasibility study. You have an engineering report which the county prepared. This was required to be prepared because the Water Management District has required that we look to these local services. And in doing the engineering study, the county targeted the part of the county which could best benefit from the reclaimed water, which would lessen the dependence on potable water. The findings of the county commission were, with respect to Madeira Beach, let's just take for an example, that 25% of the potable water sources would be reduced by having the reclaimed water available in those communities.
What is the significance, do you feel, of the exemption for those that have well water as far as determining whether this is a fee or a tax?
I think it's just one component you have to look at when you look at Port Orange. I think you look at the fact that it's not 100% mandatory with respect to this capital component, but you also have to look at a variety of other factors that distinguish this case from Port Orange. Here we're operating under proprietary, traditional, long-standing utility law. There are a lot of cases of this court which hold that mandatory fees in garbage context, sewer context, water context are not taxes. And so you look at that. You look at the fact that this is earmarked. These monies are very specifically going into the enterprise fund to pay for these pipes and these hose bibs in these neighborhoods. They're not going as Collier and Alachua and some of the other cases, they're not going into the general fund. It has no indicia of a tax that's being put in place to support the general governmental functions of Pinellas County. It's going for a traditional utility. I'd like to also say that this is a large project, although if you read the briefs, it kind of gets lost in there that it's a $200 million project. This particular component is about $16 million worth for these smaller lines. The sewer customers of the county are paying over 90% of the cost of this. There are a lot of improvements to the wastewater treatment plant. There are a lot of improvements to the pumping and storage, and there are larger transmission lines that go out from the wastewater treatment plant to these neighborhood communities. All those costs are being absorbed by the sewer customers. So again, the County Commission as the legislative body has not been shown to be acting in an arbitrary or capricious manner. They've basically had the hearings and gone out into these communities, educated citizens about the reclaimed water, received feedback, in fact, from the citizens. They didn't like the price tag. The county then went out, got a series of grants, reduced the cost from $22 million to $16 million. And as the body with making the legislative determination concerning the classes of the users, the types of fees to be put in place, they determined that these fees should be set in this manner and should be set in this amount and be charged proportionally to the benefits to these particular communities.
I didn't quite understand what you said a few minutes ago about the other costs for the system are being absorbed by the sewer customers. Are these improvements that are being made to the entire sewer system that it's really for the reclaimed water project, and the cost of those improvements are being passed on to the entire county? Is that what you're saying?
Well, you have to understand that water and sewer, as this court found in the 1946 City of Miami case, they are inextricably linked. They're really a lot of the same system. And here of this $200 million project, you have to improve the wastewater in order to turn it into the non-potable water that's safe to use in these communities. So the County Commission looked at the various and sundry amounts that would be necessary to put in place the reclaimed water and did determine that, yes, over 90% of these costs are being absorbed by the sewer customers, which is a different set of users than the water customers of the county. At this time, I'd like to go ahead and reserve the remaining time I have for my rebuttal.
You may do so.
Thank you, Your Honor.
Thank you. Mr. Atkins.
Good morning, Your Honors. If it please the Court, my name is Lee Atkinson from Hughes and Barnes, Emmett and Eunice, a Clearwater law firm. With me is Marie King from the State Attorney's Office. I represent the interveners. She represents the state of Florida. We would like to reserve 5 minutes of our time for her remarks. At the outset, we should be clear on what this case is not about. It's not about the benefits of reclaimed water. It's not about assuring that sufficient quantities of potable water will be available for future generations. It's not about the general authority of counties or municipalities to provide essential services or collect, through a lawful and permissible funding mechanism, the monies necessary to pay for them. As we stand here this morning, counsel for the appellant still has not addressed the simple, essential question. Reclaimed water is a result of wastewater. You have to dispose of it. They're under a mandate to dispose of it a new way. They're spending $200 million to do that. They're charging all wastewater producers the vast majority of that cost. Why is this additional $16 million not being spread out over the entire community, which will benefit from this system? Why are the people of the beaches being required to pay an infrastructure construction tax? The trial court said it was a tax. Well, this is what this is about. It's whether or not the county can charge.
Let me ask you a question here. But as I understood, the $16 million is actually for the pipes, or I'm not exactly sure what you call it, that actually goes to the affected properties.
Whether they want it or not. whether they will actually ever connect to the system or not. That's the point here. This is not a user fee. It's not a connection fee. It is saying to the people of the beach communities, you will pay $7 a month for the next 30 years, which is very important, so that we can run these pipes down your street whether you want them or not, whether you ever choose to connect to them or not, whether you have any use on the beaches for reclaimed water or not.
Well, are the pipes going to the other areas that you're claiming should also be participating in paying the fee?
The fees for the reconstruction of this system and its expansion should be evenly distributed over all of the people who generate the wastewater that this system will treat and then make available as a way of disposing
Now,
of.
what I'm asking you is, do these pipes go to, are there people to whom these pipes are headed, residents, that are not paying the fee?
There will be some, those who in fact are exempted by that part of the statute that says that if you already have a deep water well and therefore actually have no need for reclaimed water, you won't have to pay the fee. Everyone else will.
But that's in the area where the pipes are going,
Right.
are directed to. I'm asking you generally throughout the county, the pipes are not going to other,
The other parts of the community that either already have reclaimed water or which generate wastewater but will not be part of this additional part of the system are not paying that $7 a month fee.
okay, so your argument is that because the county has to still dispose of the waste, and this is the way they choose, that's why it should be generally applicable to
All wastewater producers, yes, ma'am.
Well, the analysis, does it not involve also a question of whether there's some special benefit that flows to the property, whether you use that or not, with regard to the availability of that service and the pipe that goes to the service? Is that not the theory?
No, Justice Lewis, that would be the theory if this were a special assessment and if we were going to analyze it as a special assessment. In that regard, I want to point out at tab X, which is the ordinance that originally started this controversy, at page 12 is a savings clause. Council disagree about what that savings clause means. Interestingly enough, the county, when they passed their ordinance, assumed that their availability charge might not be valid. They went ahead and then referenced Chapter 153 as the alternative they would look to if, in fact, the availability charge was, in fact, found invalid. Then they do an interesting thing and say at the end of that savings clause, and if we can't find a way to fund it there, we will then come back and look to creating a special assessment. As Pick Tally's testimony made clear, if you go to tab S at pages 40 through 43, the county never did any of the things necessary to make this a special assessment. They did not, in fact, analyze the individual benefit to individual homes. We asked them about specific street addresses. Do you know how this will enhance the value of that property? I have no idea. Are you charging this amount uniformly, the same amount, to every piece of land, no matter what its size, no matter what its use, no matter what its value? Yes. Can you tell me how it will enhance the value? No. It can't be a special assessment.
There are certain attributes of special assessments as opposed to the attributes of a tax. What are the attributes of the tax here?
Well, I think it goes the
Why
other...
would you put it in the tax category, and what are these special attributes that you would use for making that determination?
Well, you know, Justice Shaw, what you made clear recently, the court made clear recently on the Collier County case, where you had a basically unanimous opinion of the court, is that you go back to Boca Raton and you recognize that, wait a second, anything that doesn't meet the criteria of special assessment or permissible fee is by definition a tax. And it's either authorized or it's not. Special assessments have to meet those two specific criteria. They have to be fairly apportioned based on the enhanced value brought to the property, and they have to bring a specific benefit.
You would make it a tax by default rather than you're unable to give me 1, 2, 3, 4, 5. These are the attributes of a tax, and this is what we have here.
Again, Your Honor, I have to do it the other way around because that's the way the courts have analyzed it the other way around. When Article 7, Section 9 was passed, it limited the ability of local governments to, in fact, impose taxes. You have then said in your various opinions that, in fact, the way you fund things are through user fees, including connection fees, impact fees, which local governments have the power to impose, special assessments, everything else is a tax, and it's either been properly authorized and implemented or not. We suggest if it looks like a tax, and it walks like a tax, and it quacks like a tax, it's a tax.
But your opposition would say this is an availability fee as such. These lines are available to this geographic area.
And we suggest that nowhere in your opinions have you ever suggested that an infrastructure construction fee to make a service available was anything other than a tax. And what I would point out to you is, the county looks to some statutes for some of its proposition here that this is an authorized fee. For example, it looks to 372.250. But if we look at that statute and we go to subsection 2B, here's what it says. Reclaimed water may be presumed available to a consumptive use permit applicant when a utility exists, the county, which provides reclaimed water, the county, which has uncommitted reclaimed water capacity, which the county did, and which has distribution facilities, which is what these pipes are, which are initially provided by the utility at its cost to the site of the affected applicant's proposed use. They don't want to do that. They want to make the people on the beaches pay for that distribution facility. I suggest the statute says they have to do that at their own cost if they're going to rely on it. Similarly, they look to 403.064 and they say, well, we can charge a fee if we apportion it in a reasonable manner. We suggest that's the legislature saying you have to either do a tax, which since you are going to impose it for more than 2 years, you need a referendum to in fact authorize it, or you have to have a connection and user fee, which we did not challenge, remember. The connection and user fees are valid under Florida law. The availability charge is not. Interestingly enough, in 064, there is also some direction for private utilities that are under the Public Service Commission. And it also references back to 3670817. You read those two statutes together, and you know what they say? Private utilities who want to provide reclaimed water may do so, provided that the costs are passed on to all of their customers through the rate base. And in fact, in a 1998 decision of the First District Court of Appeals, which is Southern States Utilities versus Florida Public Service Commission, the court in fact reversed the PSC ruling, which had attempted to exclude the reclaimed water system construction costs from the rate base because that's where they belong. That's where they belong. What we have here is a situation in which rather than spread the costs of this entire project over all of the citizens of the community, or over all of the citizens who are generating the wastewater, which is the source of the problem, they have chosen to select out a portion of the cost and have it imposed on a minority group of people in the community, whether they want this system or not. And we suggest that's an illegal tax. It's not a proper funding mechanism for a bond, and therefore the bond validation failed. And the trial judge was proper in coming to that conclusion.
In terms of the special benefit, if the person who's receiving this water is there any testimony about the fact that the water bill will be decreased because of using this type of water versus the regular water?
Well, again, Your Honor, I would have to say yes, there is. That certainly the record supports the idea that if you want reclaimed water, and if you can use it for some reason, and in fact you substitute that reclaimed water for a portion of your potable water costs, then at least the usage part of your water costs will change. Now, nobody demonstrated that in fact the $7 fee wouldn't make up that difference. Nobody has demonstrated in the record that, in fact, the net benefit to a homeowner who chooses to use reclaimed water, if he can, is going to be equal to what his present costs for potable water are. There is no evidence to support that proposition in the record. What we think was highly important here, though, was, again, understand about reclaimed water. I can't connect it to my house. I can't put it in my building where somebody might mistakenly drink it. It's not that useful to those people who live on beaches with xeriscaped property or no grass, or who don't want to wash their cars themselves. And that's why we had 5 citizens come forward and say, we would opt out of this because we have no use for this.
Why is that not different or the same thing, a situation that you deal with some type of solid waste service or something like that, and the property owner would say, well, my property's vacant, I really don't want to participate, so therefore we need not, this is an invalid fee.
Here's the difference in this case, Judge. Again, if they want to charge everybody in the county on some rational, reasonable basis for this project, I think they can do that. If they want to spread the cost out over every citizen. But you see, they didn't do that here. They said, as to this discrete cost, we're only going to make the people in the beach communities pay for it. When you had a case involving, okay, can the county impose a garbage collection fee on every piece of land in the property, in the county, the answer was yes, because that was fundamentally a tax, but it was being imposed on everybody.
Well, is our status of Florida law essentially then that if a governmental unit provides some utility type service that is for a benefit of a particular area, may have some general benefit to the entire county because of the nature of it, but you cannot then receive any type of compensation from that specific area, because to do so renders that a tax as opposed to some type of utility fee then?
I would have to answer no. I think that paints the brush a little too broadly.
Where do we narrow that brush then, please?
In our case, we say you narrow it by looking at the question of what is it being charged for, okay? What is it being charged for? The wastewater services are being charged uniformly across the county. The cost of this...
Let's make sure we understand. We're talking about just the distribution pipes that run from a transmission system to each piece of property, correct?
Correct.
Okay, so that we're really not talking about the entire transmission system. We're talking about only the pipes that go to the complaining owner's property.
That's correct.
Okay, so let's go from there with that start.
All right, I find nothing in Florida law that suggests that that fee for the distribution falls within what you have recognized to be either an impact fee, a use fee, or a connection fee.
And it cannot be charged as part of any type of utility fee.
Not to the individuals if it's not spread out over the entire community. That's our position.
Well, even
Well,
though
it could be a special assessment if it meets the criteria of Sarasota in that line of cases, couldn't it?
Well, our position, Justice Wells, is that they didn't meet the criteria for a special. Could a special assessment be done under the right circumstances? Yes. Can't deny that. Can't deny. And that would be the appropriate way to do it. The user, that's why we didn't challenge the user and connection fees, because they were appropriate.
If they had called this a connection fee instead of what availability, would it have made any difference?
No, I don't think it matters what you call it, Judge. I think you have to look at the underlying facts of what is actually being provided, how is it being funded.
As I understood the argument earlier, there are some other parts of the county that have reclaimed water?
Yes.
And I would assume that in those areas, you also have these connection pipes?
And I have no reason to believe, and counsel can correct me if I'm wrong, but when those distribution lines were put in, there was not this fee for those distribution lines.
That was my follow-up question.
I knew it's where you were headed.
But how did they fund, how was it funded?
I don't know how it was exactly funded, other than my understanding of the facts is it was not funded this way. Whether it was part of the overall cost of the system at the time, or was funded through some other mechanism, but I am not aware of a bond validation based on the distribution construction charge as a collected fee being the basis of that other system.
I'm not sure about your time, but it seems to me you may be into her.
It's time for me to allow Ms. King to talk, yes.
Thank you.
Thank you.
May it please the Court, I'm Marie King, Assistant State Attorney for Bernie McCabe, State Attorney of the 6th Judicial Circuit, and it is the state's position that this is not a valid special assessment because it does not meet this Court's two-prong test for a valid special assessment. And I'd like to start with the second prong first. It works nicely that way. The second prong requires that it be reasonable and fair, and this particular special assessment cannot be reasonable and fair when, according to the county's own testimony, they are able to provide reclaimed water to only 1 out of every 4 households that produces the sewer water to be retreated as reclaimed water. In other words, these citizens on the beaches are being charged for sewer water treatment that was produced not only by their households, but by 3 other households as well, that
Well,
are
that's
not
the
being
nature
charged.
of reclaimed water, though, isn't it? Is that it takes 4 households to produce enough for one.
Exactly.
That's just the nature of it.
Exactly. So the 4 households producing the sewer water that's being treated are benefiting from the disposal. Therefore, we feel it's unfair to charge the 1/4 of the customers for that disposal of the treated sewer water.
But they won't have the benefit of being able to use
right.
reclaimed water.
That's
and
the
then
first
they will be,
prong.
well, then they will have also the restrictions, the water restrictions, and those types of things that are involved in otherwise daily living.
That goes to the first prong then as to whether or not this meets the criteria for a special benefit. And we take the position that it's going to have to meet both prongs to be a valid assessment, but we feel it does not meet the first prong either as a special benefit to the property. Now, what is reclaimed water has been discussed here today, and that it's very limited use, and it's not like the sewer and the water service, which has been by law assumed that everyone is going to need and have a necessity for. The use of water to water your yard is not a necessity. It does not equate with the same kind of a service as sewer and water, which everyone is going to have to use. It's not a necessity. It's no more a special benefit than if the county had acquired a quantity of chartreuse paint and announced that they were charging an availability fee for all of the citizens of this one area to have available to them this chartreuse paint.
Is
And they were going.
it really that extreme?
I think it is, Your Honor, because
Is fire service a necessity?
fire service is going to be a necessity like
Why?
this.
We don't have to have, in other words, I'm sure there are lots of homeowners out there that would say, no, I don't want it.
The
Don't make
interest
me
of
pay
safety,
for it,
if
right?
you, it's all right if you want to let your own house burn down, but it may affect your neighbor's house burning down
You
as
don't
well.
think it's a benefit?
I don't
to
think
a
it's the same
particular
kind of a
house
benefit. It's not the same kind of a benefit because it does not involve the safety of the community as does the fire protection.
In other words, for a homeowner to market their house to somebody else,
That's purely a commercial interest that citizens should have the right to opt out of. They can paint their house chartreuse if they want to, but they don't have to. And they can't be charged automatically for the availability of that kind of a non-necessity. And I would not equate it with the safety of a fire protection at all. It's merely watering your yard. So we feel that it does not meet either prong of this test, and that the legislature similarly has felt in its pronouncements about the new idea of this reclaimed water that they've recognized the differences. And those differences appear in Chapter 153, but additionally in Chapter 403.086, the preamble talks about there should be an incentive for the use of reclaimed water by customers. That would be a carrot approach. The county is implying a stick approach. You have to use this reclaimed water. The legislature has also talked in Chapter 373.250 of the fact that the distribution of reclaimed water is a utility cost initially. And if it's a utility cost, that means it's a cost of the general utility that can only be charged to the general public of the utility. So the distribution lines have been recognized by the legislature in that particular section, 373.250, paren 2, paren B, that the distribution lines are a cost of the utility. That means a general benefit that can only be charged to the general public. We feel that it's an invalid spatial assessment.
Thank you. Rebuttal.
As you start, would you address whether the county maintains that this is or is not a special assessment, or should come within that line of cases of Sarasota County and the Lake County case? And
Yes, Justice Wells, I'd be happy to do that. I think that Appalese would have you box Pinellas County in to having it either be a special assessment or a tax, and they would have you ignore decades of utility law in this area which has stated you can have mandatory fees. I think the county's position is that if the court does not find that it is a valid utility fee imposed under 403, the Special Acts, Chapter 180, and Chapter 373, then the court could go so far as to look at this as being a special assessment. It does, and the county, in fact, as the legislative body making the determination of how they wanted to approach this, didn't set it up as a special assessment.
What did the county do as far as this type of infrastructure in Curlew, for instance?
The county has basically gone in other areas of the county. I know some of the questions related to this. There is a reclaimed water system in the north part. The costs of those lines were done more like what you'd consider an impact fee because it was new growth and they were paid for by the developers.
So they were basically done as hookup fees?
As impact fees, if you will.
So that the builder paid at the time the house was built?
That's correct. And then in another area of the county, the Tierra Verde area, which is the very southernmost coastal community, there is a very similar structure in place. The county, in fact, went in, thought they were going to do a special assessment, had public hearings with the citizens, and determined that the citizens would prefer to have this as a utility fee on their utility bill rather than leaning their homestead. So the county totally disagrees with the idea that you have to either find this as a special assessment or this is a tax.
What about the idea, though, that if it is a utility cost or utility fee, then it does have to be spread throughout those that are the utility users? Is that
The answer to that is that it is being spread in that fashion. That has not been shown to be arbitrary or capricious. There are no findings in the record that the county's determinations about how to allocate this cost has been done in any arbitrary or capricious manner. And in fact, all the testimony and all the engineering reports have shown that they did make those differentiations in the classes of users. And I'd like to go back to this idea that they're
Well,
not...
but it's the same, I think the point I understand your opposition making about the other areas of the county, up in the north part of the county, up in Curlew and that area, you did it by impact fees, but it's the same utility, correct?
Right.
And
Those
now
are
it's
the new
being-
growth area.
Now it's being done by rather than doing impact fees, you can't do impact fees because there's not anybody building.
Correct.
any longer there.
Correct. So you do this as shown as an availability charge because otherwise these people have a windfall. Otherwise, what you're having happen is that you're going to have these benefits to these particular properties, and although they argue there are certain subclasses of a few people that won't use it, they all use potable water. We all drink water. And what the testimony is at the trial court and what the engineering reports reflect is that the primary goal we have that is driving this is the water system.
But the disparity, the thing that I'm trying to work through is the people that are living in Curlew, that are buying the house in Curlew today, somebody else paid that impact fee, they're not being charged this same.
It went into the basis of their house when they purchased the house.
But they're not today
They're being charged.
the fee for the very same service.
They're being charged reclaimed water fees for the use of the reclaimed water.
What about, did you say there was another
They
area,
are.
though, there are utility fees being charged?
In the Tierra Verde area of the county, which is an unincorporated area of the county has in fact in place a very similar system to this.
And that just was never challenged?
That's correct.
So,
Well, they didn't want it done as special assessments. When I say it wasn't challenged, I would say that the citizens were heard on that matter, and they very clearly stated that they wanted it done as a utility fee.
which is what it's
As an availability fee.
same as here.
Correct, Your Honor.
Do you have any, is there, in terms of numbers, do we know, in, say, in a comparable area, are we talking about half of the homeowners are using it, 90%?
What they've shown, and there was another study done and if you look at the engineering report in the southern portion of the county, is that the increase occurs over a period of time. At first, people may not want to use it or may not use it, and then
Maybe a psychological,
or they appreciate the neighbor's landscapings or whatever, and that it takes a little period of time before the potable use is supplanted by the non-potable water. I think it's important to talk about the fact that these people are using the water and that you can't force the county into pigeonholing this as some kind of a mandatory lien on a homestead and going to the special assessment. They're used to using their utility bills in order to recapture these type of capital costs, and you have to look at this court's long-standing traditional utility law and the cases on point. Although the appellees would have you believe that there aren't cases on point, that it really has never been the law, and this would be a departure from the long-standing utility law of the state to prohibit a county in providing water to the citizens from charging these type of capital costs through to them.
And you would distinguish that from from the transportation fee in Port Orange on the basis of Chapter 180?
Chapter 180 is a very important chapter. I think Chapter 180, although on its face it applies to cities, when you have a home rule county, the home rule county is allowed, under its home rule powers, to do anything that's not, that can do anything a municipality can do or that's not in conflict with any general law. And here, 180.02 specifically says the county could go so far as to have a mandatory hookup required. The county hasn't even gone as far as the Florida statutes allow the county to go in following the mandates of the legislature and putting in the reclaimed water. I think I'd like to just recommend a couple of cases for you to look at with respect to how the court has looked at these type of utility fees over the years, because we live in a civilized country. We live in a highly developed country, and we've long held that we can require mandatory hookups to water, to sewer, and required mandatory fees in the garbage case. And this availability charge is really no different than, for example, the Mexico Beach case that came before you in 1977, where you said, yes, you can have a mandatory flat rate for garbage, irrespective of whether you're in your condominium and putting your garbage out or not, because that is a function that county government can undertake.
Why wasn't this just put down as a hookup fee as opposed to an availability?
Why didn't the county choose?
Right.
I think the county looked at encouraging people to use this particular reclaimed water source, and in order to fairly allocate the costs over the benefited properties, they determined that they'd charge $7 that equates directly to their costs, and they would charge an additional $2 for the actual usage of the water.
Well, if this had been a hookup fee, would it be in a different category than this?
I think a hookup fee is even more extreme. A mandatory hookup fee, if you will, would be taking what Pinellas County has done and going even further. I think they could have legally done it that way. So clearly, I think they can go as far as they did in charging the availability fee to this particular class of users.
You had one more case, and then your time is...
I'd also like to recommend you to the City of Miami Springs case and that City of Miami case from 1946, which basically says the flat rate for sewer charges and water sewer charges of this nature are not taxes. And we'd like to also just request that you look at that 153 consent issue and overturn the trial court on that. Thank you.
Thank you very much. Next case on the court's calendar is the Bacardi case.